Chairman Bell, members of the committee, I'm David Fowler, President of the Family Action Council of Tennessee. 1983 graduate of the University of Cincinnati. And I will just add, I'd be happy to entertain the same questions you just asked of Mr. Kellum at the end. I support the version of the bill that is before you, though I believe the whereas clauses could actually be greatly strengthened to make it a better bill. I strongly concur in Professor McLeod's testimony regarding the Ninth Amendment basis of this bill and what the Ninth Amendment does, and I will tell you that the Ninth Amendment was not at issue in any of the cases that have been referenced today as Professor McLeod testified. That's important. I'm going to spend my time today responding to what I think you might hear from the bill's opponents, not to cast aspersions on them, but to narrow the issue. And I suspect that some will be talking about Roe and Casey.
Mr. Fowler, we're not counting this time against you. I should have asked, please silence your cell phones. I'm hearing this one go off for a second time, and please silence your cell phones.
I'm sure if the president needs you, he'll get you.
All right, thank you.
Yeah, you're welcome.
Go ahead.
Okay. Okay, so where was I? Because I suspect that what you will be hearing is about Roe and Casey's oranges analysis, whereas the Senate version is based on the Ninth Amendment apples argument. Don't get confused between apples and oranges. The bill is very clear that it's grounded in the Ninth, not the 14th Amendment. The General Assembly believes that there is a discord, this is from the whereas clauses, between the Constitution's central protections, articulated in Roe versus Wade and Planned Parenthood versus Casey, with respect to the central protections of the Ninth Amendment and the absolute right at common law of personal security that consists in the uninterrupted enjoyment of one's life. But thus the Senate version creates a conflict between two constitutional provisions the U.S. Supreme Court has never ruled on in the context of its abortion jurisprudence, as Professor McLeod said. So a 14th Amendment oranges argument against this bill misses the point of the bill's Ninth Amendment apples argument. But even as Mr. Kellum demonstrated, even the Supreme Court's 14th Amendment jurisdiction offers good reasons to stand behind the Ninth Amendment argument and basis for this bill, and let me demonstrate. In Planned Parenthood versus Casey, the court's opinion begins as follows. O'Connor, Kennedy, and Souter, justices, announced the judgment of the court and delivered the opinion of the court with respect to parts 1, 2, 3, 4A, 5C, and 6, which Blackmun and Stevens, as justices, joined. Then they offered an opinion with respect to Part 5E, in which Stevens joined. And then they had an opinion with respect to 4, 5B, and 5D that only 3 justices agreed in. Now, this is important. Who were those other 3 justices? Oh, excuse me, let me back off. In other words, 5 justices agreed on the result, the judgment. They did not agree on the why, which is the opinion. Now, let me make this distinction and its import clear for those of you who are not lawyers. The opinion of appellate court is the explanation of what the court is deciding. It is not a legally operative instrument. In other words, a court opinion is not the law. It is not an addendum to the Constitution. It is not the exercise of the judicial power. The judgment alone is the exercise of the judicial power. So, if that's the case, why should the legislative branch give deference to any Supreme Court opinion? It's because of this. Until some new evidence, new understanding of the law or history, or some new legal argument or theory comes before the legislature that would undermine the opinions of a majority, what's the point of doing the same thing? It's the reason why I did not support the natural marriage bill 4 years ago. Did the same thing in front of the same justices. So why fly directly in the face of opinions in which the majority agree? That appears to be, they can correct me, what the bill's opponents are saying, but that none of those things apply. However, ask this. If they can point to any opinion in which the court resolved the tension, the conflict between the 14th Amendment abortion jurisdiction and an abortion law based on the 9th Amendment, and whether the other rights to which the 9th Amendment applies refers to the common law understanding of a person, which included the child in the mother's womb that Professor McLeod talked about. I did not find such a case. Neither did Mr. McLeod. Thus, the constitutional grounding for this bill is that something new or different. And it distinguishes it from all other heartbeat bills and the rulings that you have heard about so far today. This is not a heartbeat bill. Get that out of your vocabulary. It's not a heartbeat bill. It's a 9th Amendment bill that deals with the questions Mr. Kellum was talking about. But even if this key point is disregarded, look at what Casey is telling you. As far back as 92, a majority of the justices couldn't agree on the reason for their judgment. That's one of the things you look at. Is there something new that the majority has said? Don't go against the majority. They didn't have 5 people that could agree. Now, this is what Justice O'Connor said about the Roe in the part of her opinion that Justice Blackmun and Stevens would not join. This is Casey. Keep in mind, Roe held the state's interest in potential life was not sufficiently compelling to put any prohibitions until the 3rd trimester. Here's what she wrote. The trimester framework does not fulfill Roe's own promise that the state has an interest in protecting fetal life or potential life. Roe began the contradiction. It's exactly what Mr. Kellum was talking about. By using the trimester framework to forbid any regulation of abortion designed to advance that interest before viability. This treatment is incompatible with the recognition that there is a substantial state interest in potential life throughout pregnancy. And you'll notice, well, you don't notice because I left it off, but she cited her Akron 1 dissent. And why did she cite her own dissent? This is what she said. The choice of viability as the point, this is from 1983. This is what led to the discord in Casey. The choice of viability as the point in which the state interest in potential life becomes compelling is no less arbitrary than choosing any point before viability or any point afterwards. Accordingly, I believe the state's interest in protecting potential human life exists throughout the pregnancy. No wonder Blackmun, who authored Roe, would not sign that part of the opinion. Now, basing the potential for the unborn becoming a constitutionally recognizable person based on the odds of surviving outside the womb is arbitrary. But basing an abortion ban on when fetal pain is felt or when a heartbeat is detected is no less arbitrary. Arbitrary is arbitrary. And arbitrary is antithetical to the rule of law. I don't care about the optics of bumper sticker, politics, or jurisprudence. Abortion stops a beating heart, but the rule of law. That's what Kavanaugh cares about. That's what Roberts cares about. That's why Kavanaugh would not support a heartbeat bill. Arbitrary is arbitrary, and all we're saying is my arbitrary is better than your arbitrary. I'm not for that. The Senate puts this question to the court. Do you want to continue with arbitrary measures of life and personhood and the state's interest in it? Or do you finally want to allow abortion policy into conformity with all other areas of law, criminal, tort, and property, so that there's uniformity of understanding regarding when the power of the state may declare the unborn a person and treat them as such? The uniformity, that uniformity, is what the rule of law requires, and Roe is an arbitrary exception to the uniformity that exists as to when the state can declare the unborn a person in the eyes of the law, everywhere else. If the Supreme Court doesn't care about the rule of law, which is what's suggested by the opposition to this bill, then heaven help us, we are lawless. Consequently, I submit that saying Roe and Casey 14th Amendment opinions tell us how the court will rule on the 9th Amendment is speculative. Moreover, look at the Supreme Court's 2007 opinion in Gonzales, already mentioned, where they upheld the partial birth abortion ban. Like Casey, there was not agreement among a majority on Casey or Roe. There were 5 people in the opinion, but not agreement. Here's what they said. Justice Kennedy wrote this: the principles set forth in the joint opinion in Casey did not find support from all those who joined the instant opinion. Those 4 other of the 5 justices were these: Roberts, Scalia, Thomas, and Alito, 3 of whom are still on the court. So what was the point of the 5? The 5 said, we assume the following principles. Now, Justice Ginsburg's dissent tells you what the majority did actually agree on, and this is important. Sometimes you find out the most from your opponents. She said, in cases of a woman's liberty to determine whether to continue her pregnancy, this court has identified viability as a critical consideration. And then she jumps on the 5 justices in the majority. Today, the court blurs that line, maintaining that the act legitimately, she's quoting from the majority, applies both pre-viability and post-viability, because a fetus is a living organism, while within the womb, whether or not it's viable outside the womb. The court admits that moral concerns are at work, concerns that could yield prohibitions on any abortion. In fact, the argument was made that an in-the-womb D&E was as brutal, if not more so, than a partial birth abortion. The court's hostility to the right in Roe and Casey is not concealed. The Senate bill draws upon these considerations and adds to it a constitutional grounding for the unborn based in the 9th Amendment, not the 14th Amendment. Now, to be fair, the court's 2016 decision in Whole Women's Health slowed the court's march toward abandoning its 14th Amendment jurisprudence. But it is not determinative of the 9th Amendment argument. Here is how the 5-member majority, which included Kennedy, tried to distinguish what I just said about Gonzales. Unlike Gonzales, here's their distinction. The relevant statute here does not set forth any legislative findings. That's just like the House bill. That's not like the Senate bill. Rather, one is left to infer that the legislature sought to further a constitutionally acceptable objective. In other words, the factors and propositions undergirding the judgment in Gonzales still exist and can be used by you as authority if you will use them in making a 9th Amendment argument. But the Senate version of this bill leaves nothing to inference. It lays a 9th Amendment axe to the root of the constitutionally diseased roots of the court's 14th Amendment abortion jurisprudence. And it is time to cut Roe down. Thank you, members of the committee.